Jeff Garfield and Douglas Hopp, Lisa Harrington and Hold 12 LLC. That's file 25-40416-GC, set for a motion. Who do I have present for that matter, please?
Good afternoon, Your Honor. Jeff Garfield on behalf of Plaintiff Jeff Garfield, PLC.
Thank you.
Your Honor, Elliot Blumberg on behalf of the named defendants.
Thank you. Looks like we have motion for summary disposition. Mr. Garfield, I believe this is yours.
Correct, Your Honor.
Go ahead and argue that if you wish.
All right, Your Honor, this is a pretty straightforward case for unpaid legal services. Plaintiff provided legal services for the defendants, namely helping form Hold 12 LLC and handle the liquor license issues, plus Doug Hoppy's child custody matter and his domestic violence case. The parties signed a written contract for legal services, and that contract names all three of them, Hold 12 LLC, Lisa Harrington, and Doug Hoppy together as a client. Paragraph C specifically includes Doug's prior custody balance of $4,167.79. The contract was done through DocuSign. Each of them received it at their personal email. They opened it, they signed it, and it's shown in the audit trail and IP logs. Now, the defendants say they never signed any contracts, but the evidence shows otherwise. And even if the court has any doubt about the signatures, their own later actions make the point largely irrelevant. After the contract, the defendants used a house charge arrangement at the bar to pay the legal bill. They actually used it for 3 months. They made partial payments totaling $3,801.96. They received signed receipts crediting the money against the legal balance. They received monthly invoices without any objection, and even admitted in their own counter-complaint that the house charge arrangements existed at their request. That kind of conduct ratifies the agreement. It also creates an account stated and implied contract and supports quantum merit. There was also a Scrivener's error in the contract that left out the $2,000 domestic violence flat fee, even though everyone understood it would be included, and they paid the full amount for 3 months. We're asking the court to reform that part, but even without reformation, the full amount is still owed under the other theories. Defendants tried to make this a veil-piercing case, but this isn't a veil-piercing case. Lisa Harrington signed the contract personally as a named client. She's jointly and severally liable along with the others. Your Honor, the documents and the defendant's own actions leave no genuine issue of material fact, and I respectfully ask the court to grant summary disposition and her judgment for $9,438.56 plus interest, costs, attorney fees, jointly and severally against the defendants, and dismiss their counterclaim. That's all I have. I did file the answer to their answer and gave you a judge's copy for that also.
I've read all of that. Thank you. Mr. Blumberg?
Well, Judge, needless to say, nothing could be more inaccurate than Mr. Garfield's representations to the court in the sense that this is a straightforward action. This is anything but that. I think the good place to start with is the complaint that was filed by Mr. Garfield. It doesn't even allege the existence of a contract, let alone the breach of the contract and any damages that may flow from it. If the court has in its file a copy of the complaint, it's interesting to note that in various paragraphs, there's reference to defendant, singular, without indicating who that is. Defendants are residents of Otsego County, Michigan. Clearly, Hold 12 LLC is not a resident of any place. It is a limited liability company having as its principal place of business Otsego County. This complaint is so poorly and inaccurately drafted that it requires dismissal on its face. Again, first-year contract law requires in any alleged breach of a contract, 1, the identity of the parties, 2, that there is a contract that's enforceable, 3, that there has been a material breach of the contract. I mean, Judge, there's nothing in this complaint that would allow the plaintiff to recover based on the pleadings on its face. It is defective at every turn. But if the court even were to say, you know, we should give Mr. Garfield an opportunity to amend his pleadings, to plead properly the existence of a contract, and that the non-payment is a material breach, the fact of the matter is that the affidavits of Lisa Harrington and Doug Hoppy clearly established that they never authorized their attorney to DocuSign their name as it relates to this contract for legal services. Again, if the court looks at the contract, it's dated the first day of March 2024. It's not DocuSigned until June. The work that was done, or at least alleged to have been done, took place well before the existence of this contract that my clients deny ever authorizing Mr. Garfield to sign. So there is no binding legal contract because they never signed it, and they signed their affidavits attesting to the fact. Now, Mr. Garfield did have the authority to DocuSign their name on documents that he was preparing for the LLC, documents that were sent to the Liquor Control Commission. He did not have the authority to DocuSign their names. They've attested to that, and that is the basis of our counter complaint that for some reason he's asking the court to dismiss today. Again, the complaint is defective on its face. The contract at least is alleged to have been signed by Mr. Garfield without authority. And there's a serious question as to the individual's liability for any work done on behalf of the LLC. The LLC needs to be sued in its own name. Mr. Garfield failed to do that, and yet they're listed as a party to this contract, and they're listed as defendants in this lawsuit. So this motion's brought both under C8 and C10. Mr. Garfield's suggesting to the court that there is no genuine issues of fact in dispute. I suggest to the court there is nothing but issues as it relates to the complaint on its face, to the contract that my clients state unequivocally that they never signed, and the fact that he doesn't distinguish between one defendant and another. The court's very well aware of the fact that in a limited liability company, as a general rule, the members are not responsible for the debts of the limited liability company, unless there is pleadings that allows the piercing of the corporate, or in this case, the LLC veil. It's pled improperly. So, Judge, for those reasons alone, we're asking the court to dismiss this lawsuit. It's not pled properly. He doesn't distinguish between defendants, and he fails to state a claim upon which relief can be granted.
Mr. Garfield, any final response?
Well, I can't do a DocuSign and put their email addresses on it, run to their house, open it up or wherever they're at, and click the buttons. They sign the contract, and yet they claim they never signed the contract. DocuSign is permissible in the state of Michigan. So there is a contract, and because it was dated March 3rd or March 1st, that was just memorialize the work that had been done. And we always talked about putting on a house charge. They didn't have to pay full amount because of how product costs are and what have you. But no, there was a contract. They knew there was a contract. They took $3,500 worth of money and took it off the contract, do these house charges, and then quit paying it. So that's all I have to say on it.
Judge, let me just, if I could just add a couple of things.
Go ahead.
Mr. Garfield suggested to the court that payment for legal services was suggested by my clients to be used off a house charge. That was Mr. Garfield's choice. He was in there on a daily basis, drinking and eating to offset whatever work he claims he did. So that's just a material misrepresentation to the court. I think my clients are entitled to their day in court, Your Honor. They're entitled to present this matter to a jury, and Mr. Garfield can come before the jury, explain what he is now saying is the case, which we believe it to be absolutely untrue. Mr. Hoppy's own affidavit attests to the fact that he never, ever made Ms. Harrington responsible for his legal fees, if there were some. His own affidavit said that Mr. Garfield agreed to do that pro bono. That's a factual question as well. I know Mr. Garfield finds this humorous. It's not. It's serious, and it's really embarrassing for all.
Your Honor, if you look at the domestic violence case.
Stop. I don't need the personal attacks, Mr. Blumberg. Mr. Garfield, I've heard from you twice now, so that's sufficient. Mr. Blumberg, the paragraph 4 of the complaint talks about plaintiff delivering to defendant certain services on an open account. would that not at least be an allegation of an implied contract in an open account for services rendered?
You can't have an implied contract if there's an assertion there is a real contract. That's his, I mean, if he said, look, we didn't have a legitimate contract for services, but impliedly I provided the work and that created a contractual obligation. That's not what he's pled. He's pled the existence of a contract. He's attached the contract for legal services. He's expressly prevented from asserting the implication of a contract.
He's pled an open account. Why would he be prevented from pleading that?
The open account arises from the contract for legal services. That's why he attached it as an exhibit.
Right. So, I mean, pleading an open account assumes that there's a contract in place.
Right. And our position is there is no contract.
So there's a question of fact, but there's the complaint at least minimally pleads contract because there's an open account stated in paragraph 4.
Well, but then there's still the requirement, the showing all of the parties to that contract and the breach of that contract. There isn't even the word breach anywhere in this complaint. I mean, it's basic contract law. I mean, those are the elements of a contract, as we all know that.
Paragraph 9 says defendants have not paid the balance owing on the account. That's a breach of the contract.
The court is putting words in the contract that don't exist.
A rose by any other name is still a rose.
But yeah, I understand that as it applies to flowers, not so much to written contracts that are prepared by lawyers.
Good point. Good point. Well, here's what I'm going to do. The thing that's in front of me today is the motion for summary disposition. I agree with Mr. Blumberg that there are way too many questions of fact for me to grant summary disposition. Mr. Garfield has admitted that the other side doesn't agree that the contract was signed. That is, in essence, the biggest deal that there ever could be in a contract case. Was there a contract that was signed or not? We can argue later about implied contracts and whether or not they partially complied or said that there was a contract by making partial payment or not. But I can't give you a summary disposition when there are such big facts still at issue. And Mr. Blumberg does make some good points about the lacking of some legal language in the original complaint. So, Mr. Garfield, I'm going to give you 15 days to file any amendments to your complaint that you wish to do. Is there any other discovery that needs to be done at this point, gentlemen?
I don't believe from our side, Your Honor. Thank you.
I may have to do some depositions now.
All right. Let's see if I can pull out. Can you print me just a free travel? If not,
I think you gave us 60 days initially, and then I think we asked the court for a short extension. And that's where we're at. I think we had 90 days, if I'm correct.
yeah, I see it here now. Discovery was 30 days from March 2nd, so that's been completed already. We were then to have a status conference in 60 days, which is basically where we're at now. And then we're supposed to be a bench trial. So, Mr. Garfield, you're asking for, can you do your depositions, whatever else you need to do in the next 30 days?
Yes, Your Honor.
All right, so I'm going to give you 15 days to amend pleadings if you wish. Discovery will be allowed by the court, completed in 30 days. Then I'm going to set it for final settlement conference. Do we need mediation of any kind, or do you want to just proceed as we are now?
We tried it once, Judge. It didn't last very long.
All right.
All the parties didn't attend.
All right, so we'll come back for a settlement conference after discovery, and I'll set trial dates. No, let me do this. I'm going to I'll have the court staff set a trial date. Let's see, 30 and about 60 days. Bench trial or jury trial?
Jury, Your Honor.
Have you filed the written request and the fee?
I'm sorry. What was
Have you
that?
filed the written request and the jury trial fee?
No, I have not. I filed a written request in the beginning, but
Well, there's a fee for that. I believe it's $50. Check with the staff. You have 7 days to pay the fee, or it'll be turned into a bench trial. 1 day trial, gentlemen?
Yes.
yes.
All right. 14 days prior to trial, there'll be a final witness list, final exhibit list, a trial brief, and complete jury instructions. And that doesn't mean I get instructions from both of you. That means I get one set of instructions agreed upon by both of you. If there's any dispute as to specific instructions, we'll hear that at the first day of trial, or the day of trial at 8:30 in the morning, prior to the jury selection process.
And Judge, I just have a question and perhaps an observation.
Go ahead.
In the original filing, there was never a jury demand and no jury fee paid. I understand he's going to amend his pleadings. I guess he should have the opportunity to, again, seek a jury trial if he wishes. Is that the court's view?
It is, but I gave him some time frames to do that, so if he fails to do it, it'll turn itself into a bench trial automatically.
Thank you.
Anything else, gentlemen?
That's all.
Thank you very much.
All right, I'll see you after discovery. Thanks.
Bye-bye.
Thank you, Your Honor.